The one thing I know, or one of the things I know that is very clear, is that admission of evidence, whether a police officer who investigated an accident issued a citation, is irrelevant and highly prejudicial. It is inadmissible. End of story. There is a lone exception where if there is some sort of opening the door because the plaintiff, in this case, if the plaintiff had painted a picture or done something to make the jury think that a ticket had been issued. In the case cited, I can't remember the name right now, the Continental Baking Company case. In that case, it was the officer's testimony himself who said, I don't remember if he had been given his Miranda warnings and had been handcuffed yet, but I think he was in the back of the car. And that was obviously, by the time he said yet, I don't know if it had happened yet, it gave the indication that it happened at some point, but the truth was that he had never been charged with that.
What was the judge's rationale, if you could help me out, for allowing that evidence to come in?
The judge's rationale was that the plaintiff opened the door by challenging or by accusing the defendants of violating a statute.
This case procedurally is a little bit different than some of the others in that now that we're into the new age of jurors getting to ask all kinds of questions, that this juror came back with a series of questions, and this is one of them. And I guess one of the things that confuses me is, from a preservation standpoint, first the attorney says it's okay to answer the question, and then he says it's not okay to answer the question, but what is it that your side claims the judge was supposed to do with the question?
Well, the question, we objected to the admission of that evidence and moved for a mistrial afterwards.
Well, there was no evidence actually admitted.
Well, it was an instruction. The judge put the evidence in.
Judicial notice given that there was no
judicial notice, which we contend is even worse. I mean, here we have a juror asked a question, and the question should have been answered.
So what was the answer that your side wanted?
I don't recall if we suggested an answer.
Say, I'm not going to answer this question?
Well, I mean, it happens all the time. Just tell the jurors that whether or not a ticket is issued is not your concern, but your job is to decide whether the statute was violated. End of story. We don't tell the jurors that, certainly a court doesn't instruct the jury that the defendant was not issued a ticket. The case was over at that point. Liability was decided.
In closing argument, which I have not read all of, I've noticed that the plaintiff's attorney brought it up pretty early on in his closing argument, and I don't know what did the defense do with the ticket in closing argument?
The defense pointed it out and reminded the jury that they were instructed by the judge that the defendant did not receive a ticket. So that compounds the problem. And the plaintiff's attorney talking about it after it had already been done, that is not something that waives the error. So the error was preserved, and it was clearly prejudicial. They have raised a harmless error analysis. I thought it was interesting that they moved this issue to the end of their answer brief, apparently hoping to convince the court that everything else was okay, so this must be okay too, and just forget about it. But it's our number one issue because I think it's absolutely clear that the final judgment has to be reversed because of that. The rest of the issues are just advisory to the trial court on retrial. The second issue has to do with the admission of Captain Richards' testimony. Now that's a little bit of a different, we have more procedural strangeness because the Frye Standard was in effect at the time that this case was tried, and the judge kind of applied a Daubert analysis, maybe sort of, talked about both, but when it goes back to trial, it's going to be a Daubert analysis.
Well, maybe. I mean, it depends whether you think it's substantive or procedural law. The rules of evidence have not been amended by the Florida Supreme Court.
True, they have not. And I don't know where that is. I know it's in the works somewhere.
It's in dispute in the committee, from what I'm told, by the way.
Disputed in the, yeah, well, that's where most things die, in committee. But that is...
The problem reading through this is that you had a fellow who might have been an expert about some things, but, you know, he hadn't really done the background information. He didn't really know exactly how long the boats were, or the draft, or the depth, the things that you would need, I think, to present more opinions and testimony than was allowed. It's just that he hadn't done the background work, wasn't it?
I would agree with you that you would need to know some of those details if you were going to try to figure out what the current was, what the current speed was.
Right.
But he didn't need to do that. He relied on eyewitness testimony as to what the current speed was. So he didn't know the draft might be important. Otherwise, the length of the boats.
What was it exactly he was going to say about currents and the like that he was not allowed to say?
He was going to testify as to causation, how, for the standard person, I think Florida has more boats per capita than any other state in the country, I think. And even though if you be out on the waterway, you'd think that most of them don't know what they're doing anyway. So I'm thinking most jurors don't understand how water works. A lot of people think that boats on water are just like cars on the street, and that would be true, except that the road moves and the cars don't have lines and there's no particular rules that apply to it. So the experience of a person who has investigated accidents and who has been on the water doing this for a living for decades would be, invaluable to explain how it is, and this was his testimony, was how a person can be forced under a barge to get where he was. He was wearing a life jacket.
But and this is where I want to follow up with that, because it was a bit confusing if you look at the record. The judge made some rulings at the outset, but then later on allowed the experts to testify. In what way was he allowed to test? What things did he say? What things do you contend that he should have said but was stopped from saying?
He should have been able to say how the causation, how Mr. Medina got under the barge.
Let me stop you there, because and help me with this. He basically testified, in my experience as somebody who's knowledgeable with the waterway, that is it because of all this traffic that caused, and with the situation of the barge and the tugboat, that caused the suction to get him underneath? Did he testify to that?
No. He was going to testify that that the sucking, the water being forced through the narrow funnel, and this was the focus of the defendant's objection, was the funneling effect. And I wish I had some way of showing you how it is, but the two vessels were bow to bow, and the barge has a bit of a slope, and the tug is up against it, so there's this gap in between, and the water coming down the waterway. Even the defense expert agreed that the flow of water that day was about 40% more than normal. A normal low ebb tide is 1.6 to 1.7. Out in the channel, and that day it was 2.3. So there's a big difference there. And this didn't even happen in the channel. This happened on the side. And what he was going to testify to is the water coming down gets blocked by the barge and the tug, has to go somewhere, and it goes down through that funnel and then under also.
The witnesses were using some sort of a large photograph or a diagram that I can't find in this record. I've been trying to understand their testimony.
Yeah.
Is there some smaller version of this thing somewhere, or is it just a bulky exhibit that never got transferred? And if you know the answer, you can chime in if you want to, yes.
Is this the same one? Or has this been modified for me?
This is not.
Okay.
This is not. Yes, Your Honor. It is a board that is about this big by this big. It's actually in my office.
It won't help me there.
No, but I could also have someone run it over.
Well, not right now.
If the court would like.
But what did the expert have to add to the question of causation? I mean, he didn't really have any methodology, and when pressed about it, the court says, in essence, your opinion is going to be to this jury that he was drawn under that tug and barge. And he says, my opinion, well, that he was drawn under the tug and barge is a matter of evidence, not opinion. What did he have beyond what was already of record to add to this question that was other than just blessing the plaintiff's theory of causation with somebody who seemed qualified?
Well, there's a person with a life jacket above the water on one side, and then he is found underneath a barge attached to the bottom, stuck there. And the question is, how did he get there? And the court even said that there could be some other explanation. You know, the court tried to find some other way. I don't think there is any other way. I would agree with you that as far as a juror, you know, it's, there's only one way that a person is going to be pulled under wearing a life jacket, which gives you about 20 pounds of buoyancy, and you're not going to just go under the water. You can't swim down with a life jacket on. That's not going to happen. So there is some element of that, except that most jurors aren't going to understand. I'm pointing like there's a jury here. There's no jury. But you know, most jurors are not going to understand how that what's the physics of it.
But it's going to have to have been a current that does it. The creature from the Great Lagoon did not suck this guy underneath the boat, and he's got a life jacket on. So the only way that he goes underneath this boat is that water flow pulls him underneath the boat.
Yes.
And I mean, I think that you don't need an expert in this case to explain that this man didn't swim underneath this boat with his life jacket on.
True, but we need an expert to explain that that is a dangerous condition that was created.
Was there some issue that was going to go to the jury other than the three that were presented to them?
Well, there's the issue on the narrowness of the waterway, which is something else that he eventually testified to. But
this theory, it seems to me, is that by the way these vessels were parked, if you will,
okay,
that you exacerbated or created a heightened flow of water through there that caused this man to be directed to a particular point where he's sucked under the barge. But you'd have to have some theory that an ordinary, reasonable, trained tug pilot would know he's not supposed to park him this way because that this is going to happen. And I don't see that that was alleged or that was a theory or that went to the jury. We just go to, did you block the navigable area? Did we have enough crew on these vessels on 4th of July? And the third one, which I'm forgetting what it was.
It's the narrowness,
it was
I think.
A duty to warn.
Okay. Yeah.
So I'm kind of curious as to what this testimony related to as to how this went to the jury.
Well, Judge, the question of whether they created a dangerous condition is related to, I mean, you could say, well, you know, how would they know that they have done this? They had been there for about 24 hours before this accident occurred, so they experienced, this was their second low tide, and they experienced the tide coming through. So I would say that if we're going to knew or should have known, then they knew or should have known that the current ripped through there because just 12 hours or 24 hours before it had done the same thing. They should also know, and expert testimony can establish, that docking or mooring the vessels in this way, and I wish you had that picture, I needed it too to understand, but the mooring them that way is going to create this problem every time you do it because the waterway is only, the central channel is 570 feet, the entire thing is 1,000 feet wide, but this barge cuts off the flow of about a quarter of the waterway, and that water has to go somewhere.
And, and this is, I'm going back to what he was not permitted, because one of the exchange between the trial judge and the expert witness back and forth, she was trying to pin him down, saying, have you done any mathematical computation? Have you done this? Do you know what I think she jumped on his case because in terms of the speed, 6 to 7 versus 6 to 9, and she jumped on his case that he doesn't know what the amount is. Was she, and that relates back to my first initial question, what is it that what was it that she did to exclude him? Is it because he does not have the mathematical computation?
It was a mixture of things, Judge. It was number one that he didn't do any calculations, and the trial judge apparently had some experience at a maritime academy maybe, or...
She's a merchant marine graduate.
Okay, merchant marine graduate, but she was convinced that that a person can calculate the speed of the current between the tug and barge at Coquina Bayside by getting the data from Egmont Key and then doing some calculations and figuring out exactly what the speed was. And there's no way to do that. There are too many variables. Our expert, You know, he tried to explain how many variables there were. Defendant's expert didn't even try to do that. He just went to the NOAA website or data and...
The regulation, though, that you're relying on, the navigational, blocking the navigational area, the purpose of that is to make sure that there aren't collisions in the navigable area, that there's enough room for vessels to pass one another and to have ordinary commerce within the lanes of traffic, right?
Yes, except they use the word waterway, not necessarily the channel. It's a little broader than that.
Any indication that regulation was there to regulate, you know, heightened currents along the edges of the water one way or the other that might be caused by vessels moored along the edge?
Well, I think, first of all, the evidence is that the vessel, the tug part of it, was sticking out into the waterway and into the channel. Right. So it's not just on the edge of the channel.
Hundreds of feet for these relatively small boats to go through that area. So from the standpoint of impeding traffic in a waterway, this is a tough case. Your real theory has got to do with currents created along the edge.
Well, I understand your point. And if this was obviously a collision in the waterway, then that would be a different story. But the violation of the statute, you know, that is there to create a free-flowing waterway, boats and everything. So the fact that a jet ski had to, you know, hit a vessel that is tied up improperly would be relevant. But also there is just a standard causation.
The collision with the little ski-doo is sort of secondary to this thing. This man can be in the water there for any of a number of reasons. He could have fallen out of a boat or been a water skier or a swimmer or whatever, and the same current structure is going to affect him, right? True.
So even without that, though, we still get back to a standard McCain analysis, the facts and circumstances, creating a dangerous condition. They had a zone, they created a zone of danger, and that zone of danger included this waterway.
You're in your rebuttal time, so
I don't want to do that.